Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at a highly unusual decision out of British Columbia. This is the case of the Queen and Cameron Hardy. Now I say the Queen because this decision was rendered September 1st, so a week before she passed. All right, let's have a look at what we're dealing with here, and we'll start off just by noting that this is a ruling with regards to Section 650 Sub 2 of the Criminal Code. So a good place to start here is going to be to actually look at that section of the Criminal Code so that we know what it is we're dealing with. All right, so bringing that up here, 650 says accused to be present, subject to subsections 1.1 to 2 and more other sections. An accused other than an organization shall, which means must, be present in court during the whole of his or her trial. So if they're trying you for a crime, you're supposed to be there so that you can see what's going on, you can understand the process, you can get a feeling for it being a fair process, ideally, and you can also participate in your own defense. You can make arguments. You can say this should or shouldn't be happening. So this is an important section. It's really sort of critical, but there are exceptions, and those are detailed down here. Exceptions. The court may, first, cause the accused to be removed and to be kept out of court where he misconducts himself by interrupting the proceedings so that to continue the proceedings in his presence would not be feasible. If you're disruptive, you may not get to stay in the courtroom. B, permit the accused to be out of court during the whole or any part of his trial on such conditions as the court considers proper. There may be circumstances where, you might not want to be there, for example, and the court can potentially allow that if they consider it appropriate. Or C, cause the accused to be removed and to be kept out of court during the trial of an issue as to whether the accused is unfit to stand trial, where it is satisfied that failure to do so might have an adverse effect on the mental condition of the accused. So this is a particular provision. It's kind of a protection of the accused provision when you're dealing with somebody who might be unfit to stand trial by reason of some sort of mental issue. So if it's going to be something where it might actually harm the accused, you can potentially have them removed for that reason. All right, so that's what we're looking at here. They want to kick this guy out of the courtroom. Let's have a look at why, because there's some interesting stuff going on in this one, and I've got some thoughts. All right, so we'll note here that appearing on his own behalf is Mr. Hardy. This is important because how do you run a trial and how do you run your own defense if you're the guy who's running the defense and you're also not allowed to be there? This has some pretty serious implications for this particular individual and his ability to conduct a defense at all. All right, let's see what the reasons say. And they're pretty short, so we'll probably just go through all of them. I begin the afternoon by reviewing the conduct earlier today of Cameron Hardy, a man known as Cameron Hardy, and I now will explain to Cameron Hardy, a man known as Cameron Hardy, of the consequences to Cameron Hardy, a man known as Cameron Hardy, if he repeats that behavior. All right, this is some unusual phrasing, and you might be thinking, what is the judge doing? Well, the judge is making fun of him. That's what the judge is doing, because it's pretty clear that Mr. Hardy is either a sovereign citizen or a freeman on the land or one of those varieties. And those people are really difficult to deal with for the courts. They tend to be really obnoxious and often annoying. So I'm guessing that Mr. Hardy had this particular turn of phrase because this is something you sometimes see with these types of people where they're like, well, I just want to differentiate. I'm not the corporation. I'm the man. And all of that is just legal crazy talk. It has no basis in anything, but people try it, and not successfully, but they try it. And I'm guessing he was getting on the court's nerves by doing this. So the court's making fun of him. And I'm all for judicial snark, but there's a certain point where it crosses a line, and I feel like that line is perhaps behind us, because let's keep going and see how this goes. The trial in relation to Prince Rupert Court Information 30766-1 commenced earlier today. Cameron Hardy, a man known as Cameron Hardy, was present at 9:30 a.m. The BC Prosecution Service had their witnesses present at the courthouse, so they're ready to run a trial, and the Crown's got all their witnesses. They're ready to go, right? This is going to happen today. However, As a result of the behavior of Cameron Hardy, a man known as Cameron Hardy, and the failure of Cameron Hardy, a man known as Cameron Hardy, to follow the direction and order of the court, I cited Cameron Hardy, a man known as Cameron Hardy, for in facie contempt of court. The sheriffs arrested and removed Cameron Hardy, a man known as Cameron Hardy, from the courthouse. So this is a power that judges have. They can declare you in contempt, and it's a fairly broad power for when you're, creating all sorts of problems. So this is a good reason not to pick a fight with a judge, because the judge has the tools to win that one. They will win. So as a result of some sort of disruptive behavior, it's just listed as the behavior and the failure to follow the direction and order of the court, but we don't actually see here what that is. He gets arrested and removed from the courthouse. It then continues and says, I shortly thereafter ordered the release of Cameron Hardy, a man known as Cameron Hardy, on a release order requiring Cameron Hardy, a man known as Cameron Hardy, to return to Prince Rupert Courtroom 200 at 11:30 a.m. or appear in Courtroom 200 by video conferencing at 11:30 a.m. Cameron Hardy, a man known as Cameron Hardy, elected to appear personally in the courtroom at 11:30 a.m. So they let him out and said, come back to court at 11:30 to explain what's going on. All right, fair enough. When the court recommenced at 11:30 a.m., Cameron Hardy, a man known as Cameron Hardy, made an apology to the court and other entities. I accepted the apology and purged the contempt of court citation. This is fairly common where there's contempt. Often it can be used to sort of extract an apology, and at that point the court may say, we're good. And that's what happened here. Unfortunately, rather than our recommencing with the trial, Cameron Hardy, a man known as Cameron Hardy, immediately then proceeded to read from a script and continued to speak over me, despite my directing Cameron Hardy, a man known as Cameron Hardy, not to speak. I adjourned court to 2 p.m. Now, this is really common with sort of sovereign citizens and freemen on the land and so forth. They'll bring in like a written document that they think contains the magic words that will make this court case go away, which is sort of modern day attempts at wizardry. That's not how court works. There are no magic words that make a case go away, because otherwise I'd be using them all the time. Like, why not? So, but this is something that happens all the time, so it's clear that he got on the court's nerves because they shut things down and said, let's come back at 2 p.m. and address this further. Based upon the actions this morning of Cameron Hardy, a man known as Cameron Hardy, it is clear to me from his conduct and defiance of the court process that Cameron Hardy, a man known as Cameron Hardy, wishes to lessen societal respect for the courts and to substantially interfere with the administration of justice. I'm not really sure how we get there. We have an assertion of that, which is probably, it may well be accurate. I would like to see more reasons as to why this is the case, but okay. They also are continuing with this whole Cameron Hardy, a man known as Cameron Hardy thing. It's getting less funny, kind of, and I'll explain why. So, Cameron Hardy, a man known as Cameron Hardy, has the right to be present in the courtroom during the trial of Cameron Hardy, a man known as Cameron Hardy, but that right is not absolute. If Cameron Hardy, a man known as Cameron Hardy, engages in this type of behavior again, I will be left with no choice but to order Cameron Hardy, a man known as Cameron Hardy, to accompany the sheriff, who will remove Cameron Hardy, a man known as Cameron Hardy, from the courtroom and place Cameron Hardy, a man known as Cameron Hardy, in the courthouse cells where Cameron Hardy, a man known as Cameron Hardy, will be linked into the courtroom by closed-circuit TV. From the courthouse cells, Cameron Hardy, a man known as Cameron Hardy, will be able to hear and see the witnesses in court proceedings. Cameron Hardy, a man known as Cameron Hardy, will also have the right to cross-examine witnesses called by the prosecution. So this is, he's not doing, the judge isn't doing this yet, but he's kind of threatening this. He's saying, we can take you down to cells and you'll still be able to participate, but it'll only be by CCTV, not in person. And you're going to be doing it from a much less comfortable seat. But you can see that he's continuing with this. Now, I don't really like that the judge is parroting this language, because this language is not legal language. And when the judge parrots it to mock Mr. Hardy, it might be seen by some people as giving it legal credibility, which is not a good thing. Carrying on. If I direct Cameron Hardy, a man known as Cameron Hardy, to accompany the sheriff, and Cameron Hardy, a man known as Cameron Hardy, refuses to do so, then I may find Cameron Hardy, a man known as Cameron Hardy, in contempt of court and have Cameron Hardy, a man known as Cameron Hardy, arrested and transported to the courthouse cells under arrest. So, if you refuse the invitation to go with the sheriff to the cells, that invitation will cease to be an invitation and it will be an arrest order. Okay. I don't know how disruptive this guy was. I'm guessing very, but so that's where that's going. At any time, if Cameron Hardy, a man known as Cameron Hardy, would like to speak to a lawyer, I will not only allow that, but I will invite Cameron Hardy, a man known as Cameron Hardy, to speak to the lawyer as soon as possible, and I will stand down court in order that Cameron Hardy, a man known as Cameron Hardy, may do so. In the alternative, I may grant the prosecutor's earlier request to proceed with the trial in the absence of Cameron Hardy, a man known as Cameron Hardy. This is the judge saying, I would very, very much like to have you talk to a lawyer, because I'm guessing that Mr. Hardy would be greatly benefited from doing so, because he might have a better chance with the trial here. Now, the rest of the text here, my face was blocking, so I'm just going to read it to you because there's not much left. So, the cells of this courthouse are the only location that will permit the required levels of security over Cameron Hardy, a man known as Cameron Hardy, and in the courtroom. Cameron Hardy, a man known as Cameron Hardy, will be linked in by closed-circuit TV. The court will have a mute button that will be activated by the court so that the court staff, the prosecutor, any members of the public, and witnesses cannot hear Cameron Hardy, a man known as Cameron Hardy, if he wishes to engage in a rant. And, I mean, fair, just this decision also kind of comes to us in the form of a rant, which is not a good thing for a decision. And I mean, I get if this guy's being disruptive. It looks like the judge has figured out a fairly decent way of working that, right? Where, okay, if you're being disruptive, we'll have to put you in a room so that you can't shout out midway through. Like if the prosecution is making submissions, you can't just interrupt that and blurt in because it's not your turn to talk yet. And, you know, we have a process. The judge is also considering the option of just having the trial without him at all, which creates some issues, right? How do you defend yourself if you don't know what's happening and you aren't able to make arguments in it? So this is a big step, right? This is a big process. And we'll just sort of read the last line here. It says, it is entirely up to Cameron Hardy, a man known as Cameron Hardy, if he wishes or if he wants to participate in the process here and watch the witnesses as the trial proceeds in an orderly, respectful fashion, free of any interruption or improper action by Cameron Hardy, a man known as Cameron Hardy. So I already mentioned that I think that parroting the language is not a great thing here. The other thing is, like, this is a big step. They're removing this guy from his own trial, and they might have good reasons. I would have liked to see more spelled out in the reasons. And I would also really, I mean, I am appreciative of judicial snark. People have seen that from decisions. But there's a point where snark turns into just outright bashing, and this is a problem. Even when you've got a guy who is this level of whatever he's doing, because there's a power imbalance here. The judge can hold Mr. Hardy in contempt. Mr. Hardy can't hold the judge in contempt. But Mr. Hardy may end up with a remedy at all of this. I don't think the prosecution is going to be super thrilled about this decision. In fact, I think the prosecution is probably going, oh no, because now Mr. Hardy may have been gifted an argument as to potential reasonable apprehension of bias on an appeal. I can't say if it's there because I haven't seen all the transcripts, right? And the transcripts might tell us a little bit more, but I think this decision goes too far. And as much as I think it's kind of funny, because it is kind of funny, but there's a certain point where there's sort of a line as to how far judicial jokes can go and how far judicial snarking can go. And I'm concerned that this one may have gone too far. I'm concerned that there are some issues on this one. But again, I can't say for certain because I haven't seen the transcripts, but this one just kind of feels bad for me. And I I'm not a person who has a great deal of sympathy for a lot of this kind of freeman on the land and sovereign citizen and whatever stuff. These are people who've often been deceived or misled into thinking that they've got some novel argument that ultimately um, just causes them to be disruptive and usually harms their own interests. Mr. Hardy's interests are not being served here by this weird argument that he's making. So, yeah. Anyway, kind of wanted to share that one with you. It's kind of a funny case, but it's also kind of a not so funny case in some ways. So, anyway, thank you for watching. I hope you found this one to be interesting or educational. Please like this video, share it with your friends, subscribe to see more content like this. And I also want to thank my Patreon supporters. If you want to join them, there's a link below. And that's at $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited. And at the $20 level, Jane Babe and Luxor, Mark, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Vicky. Thank you as well to the $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you guys next time. Thank you for watching. I hope you found this one to be interesting or educational. I kind of wanted to share it with you. I also want